Swayam Prabha. Digital India. Educated India.
A very warm welcome in the fourth module of the week 2 of the course Roadmap for Patent Creation, titled Non-Obviousness. In the earlier module, we have seen the novelty aspect. In that, we have noted that invention should be novel if it has to be considered for a patent granting. Now, we will concentrate on the second criterion for patent, that is a non-obviousness. Let us check what is the meaning of non-obviousness in a Oxford dictionary. As per the dictionary meaning, non-obviousness is not obvious, not immediately apparent or such as would ordinarily be expected, not disqualified by a obviousness from being patentable. Occasionally, as a noun, meaning of non-obviousness is that which is not obvious. So, it is very clear from the dictionary meaning that non-obviousness is not obvious. Now, as per Patent Act, how it is interpreted by the examiner. So, let us check that thing. In the last module, we have seen the definition of invention. Do you remember? Invention means a new product or process involving an inventive step and capable of industrial application. And we have seen the meaning of new product or process in detail. We also mentioned in the definition of a inventive step in the last module. What is the meaning of inventive step? Inventive step as a feature of an invention involves technical advance as compared to the existing knowledge or having economic significance or both, and that invention not obvious to a person skilled in the art. So, let us see the definition of inventive step in detail. As for that, there are 4 points. First, that is the inventive step as a feature of an invention involves technical advance as compared to the existing knowledge. So, technical advancement. Second, invention must have a economic significance. Third, it says it can have both technical advance as compared to the existing knowledge and economic significance. And fourth, it says invention should not be obvious to a person skilled in the art. So, there are these 4 points. First 3 points you can easily appreciate. Which are this first point? Technical advance as compared to the existing knowledge, economic significance, and then both technical advance as compared to the existing knowledge and economic significance. So, these first 3 points you can easily appreciate. The fourth, it says invention should not be obvious to a person having ordinary skill in the art. So, what is the meaning of this non-obvious to a person having ordinary skill in the art? So, can we say whether the invention is an adequate distance beyond or above the state of the art? That is, what is the meaning of a state of art? State of art and the invention under condition must be apart from each other. There should be some difference that can either technical or economical or both. We already know the meaning of a state of the art, right? As said earlier, it should be non-obvious to a person having ordinary skill in the art. Now, just check this thing, person having ordinary skill in the art. Take the first letter from the every word. So, we have met him in the first module, in the first week, Fosita, who have the normal skill. What is a Fosita? It is a fictional person who have a normal skill and a knowledge in a particular technical field. He or she is not a genius, but a person having ordinary skill. So, non-obviousness is to accommodate future unforeseen technological developments. We understood the meaning of a non-obviousness. However, we should know how examiner will judge the non-obviousness aspect, how he evaluates the patentability of a particular invention with respect to this aspect. This determination of non-obviousness is very tricky. We will see a few examples. Now, check this picture. Now, in this picture, the architect rearranged the iron pipes and made it as a bench for the tourist. So, what do you say? Is it obvious or it is a non-obvious? So, when you are applying the meaning of a non-obviousness, please remember Fosita, person having ordinary skill in the art. So, what do you think? It is this having this bench from that changing the pattern of the iron rods, whether it is obvious or non-obviousness? Do not you think it is a innovative way, rearrangement to create a bench? Now, you consider you as an examiner. What do you think? Whether it is a obvious or whether it is a non-obviousness? Think over. We will see another example. A situation where inventor combined a cap with a muffler. So, for example, if this is a muffler and then this is a cap. Now, here somebody will come and they will join these two things. Now, by joining these two things, they will say that okay, this is a new product I have invented which will protect the person from the cold, right. So, he had just combined these two things, right. Can you consider this is a obvious or this is a non-obviousness? Just think over that thing. We will cite one more example, umbrella and a knife. So, inventor combined knife and umbrella. So, this added what we can say the knife thing in the umbrella, that will be helpful to a person to defend in any what we can say the unforeseen situation, and he can use this umbrella to protect himself. So, can you think that this is a non-obviousness because he have added one feature in the umbrella? Think over. One more example we can say that the inventor changed the iron handle of the door and he just replaced it by, instead of iron he has taken a wooden thing. So, what do you think? Is it a patentable thing? Now, check all these 4 examples. Which are these 4 examples? Rearrangement of iron pipes, combination of a muffler and a cap, combination of a knife and umbrella, and replacing iron rod with a wooden rod, or replacing iron handle with a wooden handle. Anything you can do. So, you are just changing the material. In all 4, if you apply Fosita and a non-obviousness aspect, and then none of them, what do you think? Then if you apply that thing, person having ordinary skill in the art and the non-obviousness aspects whatever we have seen, none of them, means this any of the example will not qualify for the patent, because the person having that normal skill, he will say that okay, this is a very obvious thing, and he also can do that thing by replacing rod or by combining the two things where there is no any synergistic effect. So, they will not get qualified for the grant of the patent, as it is a mere combination or a rearrangement of the existing atoms or a replacement. Now, we will check the court perspective in the case of a Bishwajit Prasad Radheshyam versus Hindustan Metal Industries. So, Supreme Court laid down the importance of assessing the non-obviousness. Thus, in the earlier module, that is a novelty, we have seen that it concentrates on the invention if it is a new with respect to a prior art. While inventive step, whatever we have seen, it goes further and determine the quantum of improvement. This non-obviousness aspect helps to differentiate between real genius inventions from the mere workshop improvements. For determination of novelty, an exact citation in a single document is necessary. Mosaicing of extracts is not allowed. However, in the case of obviousness, many documents can be considered to check whether it is a obvious or it is a non-obviousness. Now, we will see one more example, it is from the chemistry. So, there was an opposition against one of the Indian patent applications. This opposition is one of the process in the patent prosecution. Here, as per Indian Patent Act, there are two types of oppositions, or you can say there are stages where the oppositions can be filed. One is a pre-grant opposition, that is opposition which is filed before the grant of the patent, and second is a post-grant opposition. This pre-grant opposition is filed immediately after the publication of the patent in the Gazette and before the grant of the patent. The post-grant opposition is filed after grant of the patent within 1 year. So, we will not go in details of what is that pre-grant opposition, post-grant opposition. We will not go in details, but we will just concentrate here that there is this case where the patent was under the opposition. Now, this invention was related to a process for extracting of a neem oil from the neem seeds. The process involves treating crushed needs in a Soxhlet solvent extraction. The polar solvent is used in this process. The temperature range for this experiment is 40 to 60 degree centigrade. Now, this process leads to the formation of a oil cake which is free from bitter and odoriferous constituents which are there in the neem. After that, the oil cake is fried using a solvent extraction using the exen. Now, opponent filed the opposition. What was the basis for this? Evidence was prior published documents from the book which disclosed extraction from the kernels, the seeds with a 70% alcohol, and it is mentioned that this process removes bitter and odoriferous compounds. It was also mentioned there that hexane can be used for a further extraction. Now, this will give a good quality oil. Now, how the non-obviousness aspect is judged here? This argument, it is based on the evidence of the expert who had worked in the field of extraction, that oil extraction for 30 years. The invention was held obvious on the basis of the expert opinion, as the person skilled in the art use Soxhlet apparatus at 40 to 60 degree centigrade, and it is a very common in the oil extraction industry. Now, based on this expert opinion, the patent was not granted and opposition is held. So, before filing a patent, we have already seen that before filing a patent, along with the novelty aspect, non-obviousness aspect is also important and it should be studied. Here is another example. This is a patent, if it is a patent which is related to the composition of a known ingredients, it is likely to be obvious unless the mixture or a combination leads to some new effect or a synergistic effect. If 1 plus 1 is 2, then this is not the something new and it is not, we cannot consider this for the patent. But if it is a 1 plus 1, that two things you have added, but the effect is say 4, effect is say 8, such kind of answers if it is coming, then we can say that this is a non-obvious. Now, consider this, verifying the previous predictions and no substantial addition. So, you have not done any substantial addition into the current whatever the product is there or process is there, and you are just verifying the prediction, then obviously it cannot be a considered for the patent. Inventive step is lacking and it is a obvious thing. Now, next, some cases if there is a combining 2 or 3 parts and arranging them in a sequence and changing the sequence of a arrangement. So, if there are A plus B plus C, some kind of instruments are there and you are changing the arrangement of that, from the, so previous product is having arrangement A, B and C, and you have just changed from A, C and then B. Such kind of thing, it is not considered as considered for the patent, is an obvious thing, okay, and it is not giving any additional effect. If that A plus C plus B is giving you some substantial change, economic advantage, then you can consider this for the patent. But if that kind of change is not there, then you can't consider this for the patent. Then obviously, this is not a, what we can say, based on this you can apply that obviousness test. Now, say if 3 different technologies are known and you are used in a particular industry commonly, and someone comes up with an instrument which is nothing but a mere combining 3 technologies without any addition effect. So, for example, there is a one procedure suppose, and for that one procedure already in the industry 1, 2 and 3, these 3 instruments are used, and these are present at a, what we can say, they are already in the use. Now, the person who is working in that domain, he says that okay, I will come up with an instrument and I will combine this 1 plus 2 plus 3, right, and he said that okay, after combining, this is the instrument I am considering, this I am applying for the patent. So, 1 plus 2 plus 3, these 3 things he has combined, he has put them together, he has made a nice arrangement of that, and now he can sell that particular instrument. Instead of these 3 things you are taking from different vendors or different what we can say shopkeeper or procuring from different resources, this one thing will serve your purpose, but there is no any change, there is no any addition, no economic advantage, nothing. If such kind of thing, if somebody does, definitely it is an obvious thing and you cannot consider this for the patent. Although you can say that convenience is there, but considering the patent law, it cannot be considered for the granting of patent because it lacked the inventive step. So, now you know what the non-obviousness is. Non-obviousness to a person skilled in the art, that is very important. Now, with this we come to the end of the session. In the next session, industrial application, we will check in detail the third criteria of patentability, that is a industrial application. See you in the next session. Thank you.